more immunity than Trump was asking for. Even if you impeach him, even if you remove him, you cannot indict him for any official acts. And those can be as broad as using the bully pulpit. It is insane. This is a really bad ruling. It's horrible.
Yeah, if I believe the ruling is correct, that I don't love America is a pretty harsh position right from the start.
Well, I guess I'm asking you a direct question now. Do you support this ruling? The president issues an order to an FBI field office or to its head. He says, I want you to kill a terrorist. The terrorist is threatening the country. That terrorist is an imminent threat. And that terrorist's name is Nancy Pelosi. Unreviewable. Absolute immunity for that action.
Am I crazy, or is this ruling not as big of a deal as everyone is saying? I've only glimpsed it, but we'll go through the entire ruling today. From the little bit I've gathered so far, initially, it seems like a really big deal of a ruling. And then when you look at it a little bit more and you think about it, it's probably not actually that big of a deal. But then when you look into it a bit deeper, I think it is maybe the beginning of the unraveling of our democracy. So be real. The only reason you like Hassan is because you have drifted so far right, you hate that he calls you out for basically being a Republican. Okay, if you accuse me of being like bad faith or disingenuous or whatever, then just, I don't know why you're here. Leave, okay? It's not even worth giving you oxygen. There's no reason. Because anything I say, you're just going to not believe me anyway. So don't. You don't have to believe. You don't want to. Isn't it counterintuitive to ban people who say you're arguing in bad faith? No, there are criticisms that are worth responding to, and there are criticisms that aren't worth responding to. If somebody's going to accuse you of being a liar, I'm not going to try to convince somebody that I'm not a liar. I think that there's plentiful evidence to show that I'm pretty legitimate and sincere in my political beliefs. I don't think anything has ever come out in the history of my doing politics or streaming that has ever contradicted that. I've gotten in more trouble than most people for being pretty blunt and forward about my beliefs. So this guy gave me an argument against a two-party system that I've never heard in my entire life. And it mind me. It's a pretty simple argument. I wrote this down on my iPad because it just my head so much. Because I said, like, well, look, you've got obviously tons of issues with parliamentary systems. Like, why do you think two-party system is bad? And something that he pointed out was one of the huge issues with the two-party system is if one of the parties goes really, really, really bad, you're fucked. And I thought about that for a second, because my argument against lack of diversity in a two-party system has generally been, well, there's other candidates that you can vote for. The primary system is generally a lot richer, because in a two-party system, your primary is going to have a greater diversity of candidates because they're not just going to jump to another party, which I thought was, I think is a good argument. I think he agrees. However, if one of your political parties starts to bend in a very negative way in a two-party system, you have a unique pressure to continue to appease that party, not appease that party, but you have loyalty to that party because you're not jumping ship to the other party. And there's not a competing third or fourth party in a parliamentary system that you can, when I say parliamentary, does that necessarily imply more than two parties? He used the word parliamentary system, but there's not necessarily in a multi-party system, in a, what would you call it? Two-party versus two-party system versus parliamentary. Would you just call it multi-party? Okay, I guess maybe multi-party. Or wait, you might have to have, I'm trying to think if you have to have a parliamentary system with multiple parties. I think one might imply the other. I'm sorry, I've never thought of this before, but I think, I just don't consider it. Because I think if you have a multi-party system, but you still vote for the president, that means that you can have multiple parties with the understanding that certain parties, even if they might be represented in parliament, would never, ever, ever get to choose or have any say in who the presidential leader is. Whereas in a coalition-style government, you might, well, but I mean, in a coalition government, it's not like a small party. Maybe it might not actually matter that much. But anyway, yeah, he brought that point up, and I was like, oh, shit. Because if there was a third party right now, or a fourth party, that was competing with the conservative party for conservative voters, after the primary system, maybe some conservative voters like, you know what, actually, we're going to go ahead and vote for this other conservative party, and we'll form a coalition government, but yeah. But Britain is a two-party system, and it is a parliamentary system. There are other parties that don't have a chance of getting power. Yeah, okay, yeah, maybe that'd be it. Yeah. But I've never heard that. It's kind of a civil argument. I've never heard that before. Germany had a multi-party system before the electing the Nazis, but isn't the point Isn't this the point of a constitution? I don't know how much a constitution matters if the people don't care about it. That's the thing. I'm not sure. Do you agree with the Shapiro take? Probably not. SCOTUS, presidents are immune for official acts but not unofficial acts. Dissent meaning Democrats. So you're saying Trump can run people over with a tractor. Wrong. Trump can only run people over with a tractor if he says he needs to as part of being commander-in-chief. Then he can do it. We'll get to, I was reading through this before in case it came up on, I did Piers Morgan earlier today, which was dog shit, but because it's a 4-person panel, so. A lot of people try to say, well, it's just limited immunity. It's not full immunity, okay? It's not full immunity. The indictment next alleges that Trump and his co-conspirators attempted to enlist the vice president to use a ceremonial role at the January 6th certification proceeding to fraudulently alter the election results. In particular, the indictment alleges several conversations in which Trump pressured the vice president to reject states' legitimate electoral votes or send them back to state legislatures for review. Whenever the president and vice president discuss their official responsibilities, they engage in official conduct. Presiding over the January 6th certification proceeding, at which members of Congress count the electoral votes, is a constitutional and statutory duty of the vice president. The indictment's allegations that Trump attempted to pressure the vice president to take particular acts in connection with his role at the certification proceeding thus involve official conduct, and Trump is at least presumptively immune from prosecution for such conduct. And so the immunity the presumptive immunity is quite broad. But then there's a whole question of, well, how do you even begin to probe that? And I think like questions of what type of evidence can even be considered, I think is also dealt with in here, but we'll get through that. Like I think civil immunity for public officials is probably fine. I think that's like agreeable, but can the House still impeach the president and then make criminal charges, or is that not a thing with this ruling? I don't know how impeachment would get you any closer to criminal charges here, but maybe that's how they read it. We'll see. What SCOTUS result would have been better? I'm guessing it would have been nice if they supplied an actual test to delineate between official duties and private actions. I don't know. We'll see how they rolled. So you don't like the idea that impeachment is the only way to punish an official act? Impeachment is supposed to be for removing a person from office, okay? So that you understand, historically, okay, impeaching politicians, impeaching people in the United States is very, very, very important, okay? Because without impeachment, there are 2 ways to remove somebody from office. The first way is by assassinating them, which you don't really want. And the second way is by, why don't I have anything over here? The second way is by figuring out a criminal charge, meaning if you don't like a politician, well, now we got to get some criminal charges to get him out of office. Impeachment was a happy negotiated middle ground between these 2 things. Well, what if the public doesn't like a particular elected official, but like he hasn't committed a crime? Do we have to kill him, or do we need to fix up charges, or can we impeach him on the grounds that we don't want him as president or an elected official anymore? That's what impeachment is supposed to be for. Oh, I see. Weird. Okay, this wasn't working. This reads like he has carte blanche for any coup attempt as long as he does it under the guise of upholding the rule of law. Yeah, that's kind of the issue, right? That's basically what it seems like. But who knows? Maybe there'll be more nuance in the ruling. I wouldn't trust anybody's opinion on this, by the way, unless they fully read the ruling. Everybody else. From now on, we're going to demand our level of research, okay? There's 2 huge issues, but I haven't read this yet, but my understanding is there's 2 huge issues that we'll figure out in this. One is that some people are saying, oh, well, there's limited liability or there's limited immunity because it's just official acts. That can expand to a whole bunch of things. And then 2, I believe something that's addressed in here are questions of what are you even allowed to use to show like criminal intent or to even demonstrate that something bad was done. And I think I read, I was perusing articles this morning and it looked like there were quotes coming out saying that you're not even allowed to probe on official acts because you can't use them as evidence of like, but I haven't, like I said, I haven't fully read this yet. So take everything I say with a grain of salt right now. The government asserts that these weighty concerns can be managed by the district court through the use of evidentiary rulings and jury instructions, brief for but such tools are unlikely to protect adequately the president's constitutional prerogatives. Presidential acts frequently deal with matters likely to arouse the most intense feelings. Allowing prosecutors to ask or suggest that the jury probe official acts for which the president is immune would thus raise a unique risk that the jurors' deliberations would be prejudiced by their views of the president's policies and performance while in office. The prosaic tools on which the government would have courts rely are an inadequate safeguard against the peculiar constitutional concerns implicated in the prosecution of a former president. Although such tools may suffice to protect the constitutional rights of individual criminal defendants, the interests that underlie presidential immunity seek to protect not the president himself, but the institution of the presidency. But we'll read it. Expand the court to 1912. To 1912 Dems and Republicans. Every Dem says no to impeachment. So it's good. It sounds dumb. Maybe I'm dumb and don't understand the ruling. Oh, okay. What is your take on why everyone seems to be dodging you? I think because most people know that they are completely and totally without fact, and they know that in an actual conversation they'll get demolished. So I think that we have to focus more on like how to do like the small short like TikTok videos, whatever bullshit. People seem to really like that stuff, and it seems to be the most effective way to communicate. If you want people to stop avoiding debating you, become so big people can't ignore you. I think I'm big enough that people can't really like just pretend I don't exist. But I think you can always ignore someone. You just have to not say anything about them, and then pretend that they don't exist. I think Dave Smith is a good example of that, in that like he literally, people tried to tag us on Twitter because they were saying that I was avoiding tagging him, and then he had it back and forth with me on Twitter, and now he's like, oh, I don't want to have a conversation with that guy, but his fans will just go along with it. The thing is that if your partner or your parasocial daddy is avoiding a debate, you can always find a way to rationalize it, and his fans did immediately. They 180'd immediately. I think the only way to get people to force people to have conversations with you is if you're friends with other content creators who host conversations. So like if I had a close relationship with Tim Pool, I could maybe pressure Tim Pool to pressure somebody else to talk to me. But that seems to be the only thing that works on that. But I won't focus on that right now.
What would happen if Biden basically ordered his whoever, XYZ, to investigate and arrest most of the conservative Supreme Court justices and state that he did it because they're under the control of foreign governments or whatever bullshit it was. And basically the only court left to try it, the Supreme Court, would have nothing but liberal justices as a result.
You could impeach him, but that's it. It wouldn't be, you can't review that decision.
But the Supreme Court at that point would be all liberal.
The Supreme Court shouldn't even hear it. That would be if he was having a conversation as the head of the DOJ and the FBI, these are all things that exist under the president. That's him speaking in his official capacity as president. If he wants to give orders to the DOJ to arrest political opponents and all that, yeah.
I'm curious. I listened to, I think most of the oral arguments when this was going before the Supreme Court. Do you think why do you think that why do you think that the I guess the prosecutor or the defender, I forget which one, is on the side of getting rid of this, but one of the appellants, the one that doesn't want this to happen, why wouldn't they be more progressive, being like, to be clear, if you allow this to take place, what's to stop President Biden from dismissing you immediately afterwards? Like basically making it more clear to them that like, hey, listen, if you decide this way, there's immediate repercussions that you're okaying for President Biden to do, versus being very like, Trump could have done SEAL Team 6. Why not say, hey, what's to stop Biden from saying that you guys are an agent of Russia and dismissing you tomorrow?
I think that question, I don't remember if that came up in oral arguments or if that was asked in the media, but this question has been asked already. Yeah.
Yeah, but in the media, I think is different than.
No, yeah, I understand. I don't remember if it was asked in oral arguments. It might have literally come up in oral arguments. I don't remember. Destiny, no, it's not in his official capacity to get them to do anything he wants. He's still bound by the Constitution. Blazing Tiger, with all due respect, you're dead wrong, and you have no idea what the you're talking about. The whole point is that when he's acting in his official capacity, it's not on you. Who the are you, an ordinary U.S. citizen? Why the would you think that you could have anything to say about the criminal liability of the president when he's acting in the official capacity as president? Not only are you wrong, you should be assassinated, because the president has the right to do that to protect the country, and it's not even available for judicial review. You're dead wrong, and you deserve to have whatever the president does to you, because he's allowed to do that. Because that's what we've all decided now, apparently. Okay.
When you talk with these conservatives coming up, I assume about this and how this is a good thing and everything. How hard do you plan on pushing? Like, so to be crystal, is it okay right now if Biden feels that Trump is controlled by Russia and has him
It's
the XYZ?
I
know there are
I
other-
will write a list of strategies out for it. I can guarantee you, clip me right now. They will never, ever answer a direct question about Donald Trump. I won't even be able to finish the sentence before, what about Joe Biden? What about Joe Biden? What about Biden? What about? Like, that'll be the first thing that comes out. There is absolutely no.
Don't even ask about what Trump's done. Being like, hey, so it sounds like anything in official capacity is okay.
Yeah, then I mean, I could try it. I'll ask, but the answers are always retarded. There is no, you're like asking me like, what do you think is like the steel? There is no steel man. This is unfathomably retarded. This wouldn't be even remotely defended for any type of Democrat asking for this. Like Republicans would roll themselves and their lard asses out of bed to go and revolt against the government if a Democrat was even considering asking for something like this. So there's no defense whatsoever. It's total delusional fantasy. If you were to ask them about what if Biden would do this, they would say something like, oh, well, Biden probably would do that anyway. He's already using the DOJ to prosecute his political, but they would say something like that. They would just, there's absolutely no steel man for this. I can't think of one. I mean, I could, but it's dog shit.
With elections being, I mean, that would be the something. What do they hate? What do they hate? They hate mail-in voting, and there's got to be something the president can do. Be like, I don't fucking know. He can just say he's going to only use his electors moving forward, right? Which is what Trump tried to do.
Yep.
So are you all right with Biden only accepting his electors moving forward?
Okay. I mean, I can try asking him. It's just gonna.
How do you think they would feel?
They're just gonna say something like, "Oh, well, hopefully the people stop it. Like good people would stop that. They wouldn't let that happen, or something like that."
Why is that bad? That's what Trump tried to do.
That is what he tried to do. Yeah.
But was Trump trying to do something bad? I'm confused.
Was Trump trying to do something bad? When you say bad, do you mean immoral or illegal?
Both.
Well, illegal, I guess is. I'm not sure the answer to that now. It's possible that the entire case for January 6th dies because the president can literally do anything in his official capacity as president that is beyond criminal review. So I'm not sure yet. Immoral, I mean, I would argue that anytime the president tries to circumvent the peaceful transfer of power, it is probably contrary to one of the most fundamental aspects of our country and our democracy. So I would say it's highly immoral and unethical. Yeah.
I think pushing them on can Biden do what Trump did would be the...
Yeah, but they already think that Biden has done worse than Trump's done. They already downplay all of Trump's actions, and they think that Biden has already done way worse than any...
Yeah. So just say, okay, yeah, you're right. Biden's worse, but we're just going to do what Trump did moving forward. We're going to use our own electors. And now the Supreme Court said that's okay. Is that all right?
Maybe, yeah. I guess we could try it. The president has duties of unrivaled gravity and breadth. Referencing Trump v. Vance. His authority to act necessarily stems either from an act of Congress or from the Constitution itself, referencing Youngstown Sheet and Tube Company versus Sawyer. In the latter case, the president's authority is sometimes conclusive and preclusive. When the president exercises such authority, Congress cannot act on, and courts cannot examine the president's actions. That's important to understand. When the president exercises such authority, Congress cannot act on it, and courts cannot examine the president's actions. So to be clear, when somebody says the court can't examine it, what that means is that there is no criminal review, meaning if you do it, you can't even ask the question legally of, was that allowed? Was it not allowed? I don't know. The court's not allowed to even look at that particular thing. Courts may not inquire into the president's motives. Such a highly intrusive inquiry would risk exposing even the most obvious instances of official conduct to judicial examination on the mere allegation of improper purpose. Just an allegation doesn't give the court the right to examine something, though, right? I could allege somebody raped somebody. That doesn't give the court the right to review that. Or it doesn't give them, it doesn't mean that is going to come under review, right? There are other thresholds that have to be met, right? Like probable cause or Nor may courts deem an action unofficial merely because it allegedly violates a generally applicable law. Otherwise, presidents would be subject to trial on every allegation that an action was unlawful, depriving immunity of its intended effect. With the above principles in mind, the court turns to the conduct alleged in the indictment. This just seems so wild. I'm so curious what the counter, how they're going to say like, oh, but don't worry, this is how we're balancing the other side. Does this mean that if the president commits a crime as an official presidential action, it can't be prosecuted? For instance, the president orders by way of executive action the assassination of their political opponent. Well, they would have to claim that it's coming under the core power of a president, but they're about to give some examples, so we'll see. With the above principles in mind, the court turns to the conduct alleged in this indictment. Certain allegations, such as those involving Trump's discussions with the acting attorney general, are readily categorized in light of the nature of the president's official relationship to the office held by that individual. This is so crazy, too. This is what the, was it Jackson? One of the Supreme Court justices, or was it a reporter that wrote this in an article, is basically talking about how now, in order to prove these allegations, you're working with like, do they call it a three-legged stool? That like, okay, well, look, so Donald Trump goes on TV and he says like, oh, I'm going to go talk to Pence. I'm going to go talk to Pence in order to rig the election. Then he goes and he talks to Pence about how to rig the electoral votes. And then somebody says, okay, well, we're going to sue the federal courts are going to press charges against Trump. Like the DA is going to file a case and go like, well, hold on. What are you going to take a case against him for? Because he literally just said, like, look, he's obviously talking to Pence here in order to like commit a crime. He's trying to rig the election. Okay, you're not allowed to consider Trump's motivations. He's still acting in his official capacity as president because he's allowed to talk about the electoral vote. That's part of the purview of the jobs of the president and the vice president. That's like, yeah, that's... The indictment alleges that as part of their conspiracy to overturn... Let's say, for instance, that something came out where Donald Trump is a woman, and then you find out, oh, Donald Trump talked to the FBI to send the FBI to go capture this woman to bring him to his office to... It's like, okay, well, we need to probe that. Wait, excuse me. Donald Trump is the executive. Okay, the Department of Justice serves under the executive branch where the president's the head of. The FBI is part of the DOJ. You can't review that. You can't even ask questions about that because Donald Trump is allowed to talk to the DOJ. He's allowed to talk to the FBI. It's literally part of the core functionality of the executive. That's not reviewable. You can't even ask questions about that. Okay. Destiny, it makes sense. It's comparable to attorney-client privilege. Okay, Leon's Law. You're a lawyer guy. My understanding is one of the few times you're allowed to pierce the corporate or the attorney-client privilege is if you are using your lawyer to commit a crime, though. Is that not true? Like if you're talking to your lawyer, and you're like, hey, can you give me some advice on like how to commit a crime and all that? I'm pretty sure that if prosecutors can show that that's the case, I think they can pierce that privilege. I don't think you're allowed to do that. Wait, I can look this up real quick. Can you commit piercing attorney-client veil used to commit crime? Oh, the crime fraud privilege. The crime fraud exception pursuant to section 90.502, there is no attorney-client privilege when the services of the lawyer were sought or obtained to enable or aid anyone to commit or plan to commit what the client knew was a crime or fraud. So the presidential immunity here seems to be stronger because you can't even, the fact that the president has a relationship with certain people means that it's beyond review. Like you would assume that it's a core thing. So it seems like what's being suggested for the president would be even stronger. According to the indictment, Trump met with the acting attorney general and other senior Justice Department and White House officials to discuss investigating purported election fraud and sending a letter from the department to those states regarding such fraud. The indictment further alleges that after the acting attorney general resisted Trump's requests, Trump repeatedly threatened to replace him. The government does not dispute that the indictment's allegations regarding the Justice Department involve Trump's use of official power. The allegations, in fact, plainly implicate Trump's conclusive and preclusive authority. The executive branch has exclusive authority and absolute discretion to decide which crimes to investigate and prosecute, including with respect to allegations of election crime. Then they cite to Nixon. And the president's management of the executive branch requires him to have unrestricted power to remove the most important of his subordinates, such as the attorney general, in their most important duties. Citing to Fitzgerald again, the indictment's allegations that the requested investigations were shams or proposed for an improper purpose do not divest the president of exclusive authority over the investigative and prosecutorial functions of the Justice Department and its officials. Because the president cannot be prosecuted for conduct within his exclusive constitutional authority, Trump is absolutely immune from prosecution for the alleged conduct involving his discussions with Justice Department officials. This sounds like, so they're not leaving this part up for interpretation. It sounded like earlier they were saying the lower courts need to distinguish between some things, but it sounds like for some of these they're just saying like, no, that's wild. Holy shit. The indictment next alleges that Trump and his co-conspirators attempted to enlist the vice president to use his ceremonial role at the January 6th certification proceeding to fraudulently alter the election results. In particular, the indictment alleges several conversations in which Trump pressured the vice president to reject states' legitimate electoral votes or send them back to state legislatures for review. Whenever the president and vice president discuss their official responsibilities, they engage in official conduct. Presiding over the January 6th certification proceeding, at which members of Congress count the electoral votes, is a constitutional and statutory duty of the vice president. The indictment's allegations that Trump attempted to pressure the vice president to take particular acts in connection with his role at the certification proceeding thus involve official conduct, and Trump is at least presumptively immune from prosecution for such conduct. I don't understand how broad this is. So, like, let's say, for instance, Trump says, I think that in the January 6th, I think that in January 6th, when we count the votes, we should have it as part of the ceremony. We should have 100 children being shot with AK-47s. Actually, let's bring them. Let's bring 100 children, line them up, shoot them with AK-47s, right? And then I've got I already bought the guns. I've already contacted the people. We've already adopted the show. Like, it'll be great, okay? You're saying that, like, okay, well, hold on. You can't talk about conspiracy to commit a crime or anything. He was talking to him about the January 6th stuff. This is part of his powers as the president, to talk about the January 6th stuff. Like, what I'm looking for here in the decision is, okay, fine. I think that any reasonable person, the most liberal, would agree that the president probably is due maybe some form of criminal immunity for, like, core executive powers. Maybe. I think that argument can be made. This, however, sounds so broad. Like, because they're not talking about Donald Trump was speaking as the president about the procedures of the electoral vote counting. They're saying that just the fact that he was having a conversation about it at all, and because of who he is and who the vice president is, everything within that conversation would fall under presumptive immunity from prosecution. That's just a wild, yeah. Presidents cannot be indicted based on conduct for which they are immune from prosecution. On remand, the district court must carefully analyze the indictment's remaining allegations to determine whether they too involve conduct for which a president must be immune from prosecution. And the parties in the district court must ensure that sufficient allegations support the indictment's charges without such conduct. Testimony or private records of the president or his advisors probing such conduct may not be admitted as evidence at trial. Oof, that's like a big memer. So that means that, so like if the president said something, I'm trying to imagine, if the president said something to Pence where he was like, listen, I'm going to give a big speech tomorrow to rile people up to go and like fight at the White House or fight at the Capitol building, and then you guys are going to overturn the election. Okay, that's great. Then he gives his speech the next day in the ellipses or whatever. If a court were to say, okay, hold on, we know this speech was given, you were literally trying to incite people to riot. We literally have you saying to Pence, then the court would say, sorry, hold on, excuse me. Donald Trump was speaking as a president to his vice president. You can't use that as evidence for another crime. So I feel like then if you're a president, as long as you're plotting crimes or you're conspiring in conjunction with doing an official act, this is the three-legged stool. Yeah, this is the three-legged stool that was brought up then during the oral arguments, that any crime that you've committed while you're doing an official act as president makes it immune for not only prosecution of that particular crime, that can't be used to talk about any other crime, which is interesting. Somebody said, yes, and if it's found out, then impeach and remove them. We're not talking about impeachment or removal here. Why would you bring that up? I don't understand why you would. You aren't invincible. You just have to impeach and remove them first. What about impeaching somebody all of a sudden means that the presidential conduct is now under criminal review? Is that going to be in here later? Spree, or are you just talking out your ass? Maybe that'll come up later. We'll see. But I haven't seen them say anything about that yet. Trump asserts a far broader immunity. Trump asserts a far broader immunity than the limited one the court recognizes. This is the limited one? Christ. Trump asserts a far broader immunity than the limited one the court recognizes, contending that the indictment must be dismissed because the impeachment judgment clause requires that impeachment and Senate conviction precede a president's criminal prosecution. Oh, this was another argument that had been floated that was beyond stupid. We'll see if the court said that agreed with this. But the text of the clause does not address whether and on what conduct a president may be prosecuted if he was never impeached and convicted. See Article 1, Section 1. Historical evidence likewise lends little to support Trump's position. Well, that's good at least, I guess. Oh, so this is addressing that the judges are basically saying that you're retarded on Spree. So you literally just brought up the conspiracy theory that is now addressed right here. This idea was stupid. Historical evidence likewise. The Federalist Papers on which Trump relies concerned the checks available against a sitting president. They did not endorse or even consider whether the impeachment judgment clause immunizes a former president from prosecution, transforming the political process of impeachment into a necessary step in the enforcement of criminal law finds little support in the text of the Constitution or the structure of the nation's government. Oh, okay, cool. That was the thing that we were referring to. I said, if you go back and you read the quotes, it doesn't seem like they were arguing that like you need to impeach somebody and then a criminal thing can happen or whatever. I don't think there's any. Yeah, that's bullshit. Destiny, genuine question. Presidents have not been charged over official acts for years. Doesn't this ruling just maintain the status quo? No, that is a dog shit, bullshit, stupid answer. Okay. Anybody that furthers that is being disingenuous. The idea that just because somebody hasn't been charged with a thing means that nobody ought to be charged with a thing misses one key component of how customs are developed, and that's that nobody has done the particular thing because they have the assumption that they would be charged with a particular thing. When people say, and there's a very common argument that's furthered in favor of Trump, oh, nobody's been charged with this before, therefore we should never charge somebody with it. The reason why nobody's been charged with it might be because the President of the United States has always operated with the assumption that if he did do it, he would be charged for it. So he doesn't do that particular thing. Just because a person in a certain role hasn't committed a crime and therefore hasn't been charged with a crime doesn't mean that all future people could commit crimes because no charges have happened yet, okay? Okay. Yes, but is what he did even defined as a crime when he did it? Yes, there are 4 criminal statutes that are cited in the Jack Smith case for crimes that he are alleged to have broken. Okay. This case is the first criminal prosecution in our nation's history of a former president for actions taken during his presidency. We are called upon to consider whether and under which circumstances such a prosecution may proceed. Doing so requires careful assessment of the scope of presidential power under the Constitution. We undertake that responsibility conscious that we must not confuse the issue of a power's validity with the cause it is invoked to promote, but must instead focus on the enduring consequences upon the balanced power structure of our republic. When he says we undertake that responsibility conscious that we must not confuse the issue of a power's validity with the cause it is invoked to promote, this seems like it's getting at the idea that I said earlier. It's like, okay, well, hold on. You can't just say like, oh, I was talking to Pence when we were, conspiring to commit crimes, so it should be fine because it's under my core powers. They're saying, okay, well, hold on. Just because that particular power to confer with your vice president over these things, is valid, doesn't mean that you can just invoke it to protect any behavior, right? We'll see how they balance that here, basically. The parties before us do not dispute that a former president can be subject to criminal prosecution for unofficial acts committed while in office. See, it's a tape recording, TR, I don't know, oral argument, blah, blah, blah. They also agree that some of the conduct described in the indictment includes actions taken by Trump in his unofficial capacity. They disagree, however, about whether a former president can be prosecuted for his official actions. Trump contends that just as a president is absolutely immune from civil damages liability for acts within the outer perimeter of his official responsibilities, he must be absolutely immune from criminal prosecution for such acts. Brief from petitioner, he's citing other things. Trump argues that the bulk of the indictment's allegations involve conduct in his official capacity as president. Although the government agrees that some official actions are included in the indictment's allegations, it maintains that a former president does not enjoy immunity from criminal prosecution for any actions, regardless of how they are characterized. We conclude that under our constitutional structure of separated powers, the nature of presidential power requires that a former president have some immunity from criminal prosecution for official acts during his tenure in office. At least with respect to the president's exercise of his core constitutional powers, this immunity must be absolute. As for his remaining official actions, he is also entitled to immunity. At the current stage of proceedings in this case, however, we need not and do not decide whether that immunity must be absolute or instead whether a presumptive immunity is sufficient. Article 2 of the Constitution provides that the executive power shall be vested in a president of the United States. The president's duties are of unrivaled gravity and breadth. Trump v. Vance. They include, for instance, commanding the armed forces of the United States, granting reprieves and pardons for offenses against the United States, and appointing public ministers and consuls, the justices of this court, and officers of the United States. He also has important foreign relations responsibilities, making treaties, appointing ambassadors, recognizing foreign governments, meeting foreign leaders, overseeing international diplomacy and intelligence gathering, and managing matters relating to terrorism, trade, and immigration. Domestically, he must take care that the laws be faithfully executed, and he bears responsibility for the actions of the many departments and agencies within the executive branch. He also plays a role in lawmaking by recommending to Congress the measures he thinks wise and signing or vetoing the bills Congress passes. No matter the context, the president's authority to act necessarily stem either from an act of Congress or from the Constitution itself. In the latter case, the president's authority is sometimes conclusive and preclusive. When the president exercises such authority, he may act even when the measures he takes are incompatible with the expressed or implied will of Congress. The exclusive constitutional authority of the president disables the Congress from acting upon the subject, and the courts have no power to control the president's discretion when he acts pursuant to the powers invested exclusively in him by the Constitution. If the president claims authority to act, but in fact exercises mere individual will and authority without law, the courts must say so. In Youngstown, for instance, we held that President Truman exceeded his constitutional authority when he seized most of the nation's steel mills. But once it is determined that the president acted within the scope of his exclusive authority, his discretion in exercising such authority cannot be subject to further judicial examination. The Constitution, for example, vests the power to grant reprieves and pardons for offenses against the United States in the president. So something that would be very interesting here, I don't know if they'll address it in here, is one of the examples that was given was, okay, well, the president of the United States exclusively has the power, and it is literally granted explicitly in the Constitution to grant pardons. What if the president accepts a bribe for the pardon, right? This is what the three-legged test was memed about. Well, let's say that he accepts a bribe. How can I even prove that that was a crime if I can't even examine his acceptance of the bribe? Because the act that it was tied to was pardoning somebody, basically, right? If you wanted to examine that in court, you would go to court and you'd say, hey, I want to prosecute Trump because this guy gave him $1,000. Like, why do you want to, how can you prosecute somebody for taking money? Well, because he gave him $1,000 and he wanted him to do something. Right? What do you mean gave him $1,000 and wanted him to do something? He gave him $1,000 as a bribe to pardon somebody. Pardoning? Whoa! Sorry, sir. That's an official power of the president. I didn't even hear what you just said. I'm sorry. Excuse me? Like, how would you even prove that crime if you can't even talk about the core function of what the president's doing? It seems like it would make it impossible. This is the three-legged stool argument. How would you even do it? But we'll see. We'll see. That must be addressed in here, so we'll see. The Constitution, for example, vests we just read this, the power to grant reprieves and pardons for offenses against the United States in the president. During and after the Civil War, President Lincoln offered a full pardon with restoration of property rights to anyone who had engaged in the rebellion, but agreed to take an oath of allegiance to the Union. But in 1870, Congress enacted a provision that prohibited using the president's pardon as evidence of restoration of property rights. Chief Justice Chase held the provision unconstitutional because it impaired the effect of a pardon and thus infringed the constitutional power of the executive. To the executive alone is entrusted the power of pardon, and the legislature cannot change the effect of such a pardon any more than the executive can change a law. The president's authority to pardon, in other words, is conclusive and preclusive, disabling the Congress from acting upon the subject. When you say conclusive and preclusive, conclusive meaning that the president decides it, and preclusive meaning no one else can, right? That's essentially what we're saying, right? Destiny, the act of bribery is separate from the act that he would commit for the bribe. No, it's not. Accepting money on its own is a crime that would be outside the president's duty. No, accepting money is not a crime. What are you talking about? No, it's not. Some of the president's other constitutional powers also fit that description. The president's power to remove and thus supervise those who wield executive power on his behalf, for instance, follows from the text of Article 2. We have thus held that Congress lacks authority to control the president's unrestricted power of removal with respect to executive officers of the United States whom he has appointed. They're citing other cases here. Citing the president's exclusive power of removal in executive agencies as an example of conclusive and preclusive constitutional authority. Okay. The power to control recognition determinations of foreign countries is likewise an exclusive power of the president. Congressional commands contrary to the president's recognition determinations are thus invalid. Yeah, it might not be three-legged stool. It might be one-legged stool. I might be citing that meme wrong. Congress cannot act on, and courts cannot examine, the president's actions on subjects within his conclusive and preclusive constitutional authority. It follows that an act of Congress, either a specific one targeted at the president or a generally applicable one, may not applicable. Is it? Can it be said both ways? Applicable one, may not criminalize the president's actions within his exclusive constitutional power. Neither may the courts adjudicate a criminal prosecution that examined such presidential actions. We thus conclude that the president is absolutely immune from criminal prosecution for conduct within his exclusive sphere of constitutional authority. Hello?
Civil law. I saw you were discussing Constitution. I thought maybe I dropped wanted.
Oh, I'm on page 20 of 120, so I'm just reading through the Supreme Court decision.
Okay.
Do you have you read it all, or did you read through parts of it, or?
I read through the majority opinion.
Any feelings?
Yeah, I'm a little confused. The Supreme Court didn't give enough guidance on what happens if it falls into this middle ground category. So basically, the president's acts can fall into one of three categories. The core acts, which are constitutionally delegated.
Yep.
They are
the perimeter acts, and then the
just him.
Unofficial ones, I think, right? It's like core acts, there's perimeter acts, and then there's unofficial actions. So actions essentially as a private citizen or whatever, yeah.
Yeah, correct. So the middle part is where it's a little bit vague because they say it's presumptively, he's presumptively immune, but they don't really give a very strong test for how to determine whether there really is immunity or not. So it's a little vague in the middle part.
Sure. I haven't gotten through. I don't think I've even read through because this is the majority of your opinion of the full thing. I'm only on page 17, but I don't even know if the core thing is spelled out well with the way that they're doing this criminal, with the way that they're doing this immunity. So I'm curious. Let's say I go up to the president of the United States and I say, "Hey, listen, can you pardon this guy? I'm going to bribe you. I'll give you $1 million." Is that a thing that could never be criminally prosecuted?
For the pardon itself, yes. For the bribe, no.
What am I bribing for if you can't review the pardon?
Yeah, the bribe itself, I think you could.
What is the bribe? What is the?
No.
I can't review the president to see if he actually did the thing, though, or if he had any intention of doing the thing, though. Wouldn't the action just be taking money?
That's a fair point. So it might be the case that in that case, the bribe would be legal.
So then it feels like, so what if I go to the president is the commander in chief. What if I pay him $1 million to go and assassinate some dude I don't like in Britain? Can I just, is the president like for sale? There's like no way to review any of those actions. I feel like commander in chief is probably core. I don't know. Because I know that some people are probably going to come away from this thinking like, man, what is the outer perimeter of the president's duties? But I'm thinking like, man, permanent, like absolute criminal immunity, even from the core duties, is kind of weird. And the fact that you can't even consider motivations or anything. But maybe, I don't know, maybe they'll discuss it in here. But
the not considering motivations isn't that atypical when we look at, for example, just a standard roadside stop. We don't ask the police's motivation in doing the stop. We simply ask whether or not they have a legal basis to do the stop. So not looking at motivations isn't that odd.
We're not talking about the prosecutor here, though, or the law enforcement officer, though. Aren't we talking about the person being criminally indicted or being charged with a crime? Isn't the motivation there pretty important?
Well,
in fact, I'm sorry. The motivation isn't important. Isn't the motivation of the utmost important? Isn't that where our mens rea comes from for a criminal act?
No, not strictly speaking. Motive is never an element of the crime. You never have to prove motive. So
maybe not motive, but like how do you separate like motive from like state of mind, I guess?
Well, the difference between intent and motive is the intent is the desire to do the thing. The motive is the reason why you're doing the thing. So to use an example, if I go to rob a bank, my intent is to rob the bank. My motive is unclear. Am I doing it for the money? Am I doing it for fame? Am I doing it because I'm trying to impress a girl? So there's a difference between my desire to do the act and my reason for doing the act.
You can never use conversations that might have been subpoenaed or obtained prior to robbing the bank to establish the intent? You
can typically, but here they're not allowing that. So it is an exception to the general rule.
Okay, yeah. It's going a bit further. It feels like...
Yes, that's true.
Yeah, it feels like there's a lot of stuff then that I think we could very clearly... But like I said, I've only gotten through page 17, so... Okay. Okay. But of course, not all of the president's official acts fall within his conclusive and preclusive authority. As Justice Robert Jackson recognized in Youngstown, the president sometimes acts pursuant to an express or implied authorization of Congress, or in a zone of twilight where he and Congress may have concurrent authority. The reasons that justify the president's absolute immunity from criminal prosecution for acts within the scope of his exclusive authority, therefore, do not extend to conduct in areas where his authority is shared with Congress. We recognize that only a limited number of our prior decisions guide determination of the president's immunity in this context. That is because proceedings directly involving a president have been uncommon in our nation, and decisions of the court in this area have accordingly been rare and episodic. To resolve the matter, therefore, we look primarily to the framers' design of the presidency within the separation of powers, our precedent on presidential immunity in the civil context, and our criminal cases where a president resisted prosecutorial demands for documents. Section 1. The president occupies a unique position in the constitutional scheme as the only person who alone composes a branch of government. The framers sought to encourage energetic, vigorous, decisive and speedy execution of the laws by placing in the hands of a single constitutionally indispensable individual the ultimate authority that, in respect to the other branches, the Constitution divides among many. I'm sorry, I'm being so pedantic here, but is that necessarily true? Couldn't you argue, theoretically, couldn't you get rid of every single judge except for one Supreme Court justice who does every single federal case? Couldn't you theoretically do that?
The Constitution only requires that there be a Supreme Court and a Chief Justice, but the Constitution also does not give the Supreme Court original jurisdiction for many cases. So you could have only a Supreme Court, but if you did that, they wouldn't be able to hear a lot of federal cases.
And so constitutionally original jurisdiction is prohibited?
Yes.
Okay. All right. And then sorry for chat. Original jurisdiction means that the Supreme Court can only hear a case on appeals that was considered by a lower court first, not that they can be the first ones to hear any case ever, correct?
Correct. They have very little authority to hear cases as the trial court.
Mm-hmm. Okay. Well, let's see. Enhance a single constitutional. Okay. Okay. They deemed an energetic executive essential to the protection of the community against foreign attacks, the steady administration of the laws, the protection of property, and the security of liberty. The purpose of a vigorous and energetic executive, they thought, was to ensure good government, for a feeble executive implies a feeble execution of the government. The framers accordingly vested the president with supervisory and policy responsibilities of utmost discretion and sensitivity. He must make the most sensitive and far-reaching decisions entrusted to any official under our constitutional system. There accordingly exists the greatest public interest in providing the president with the maximum ability to deal fearlessly and impartially with the duties of his office. Appreciating the unique risks to the effective functioning of government that arise when the president's energies are diverted by proceedings that might render him unduly cautious in the discharge of his official duties, we have recognized presidential immunities and privileges rooted in the constitutional tradition of the separation of powers and supported by our history. One thing that I hope they address in here, I don't know if they will, but they keep using this phrase, unduly cautious. Not all caution is undue. Some caution is good. I would argue in the United States, the vast majority of criminal statutes represents good caution, right? That you would want to be duly cautious not to rape somebody because you might be breaking a law, or not to murder or steal because you might be breaking a law. I hope they get into what the unduly cautious part is here, because there might be, maybe it's good, for instance, I personally, now, I'm not as imaginative as Trump's legal team, but I can't imagine a case where the president of the United States would need to rape somebody as part of his core constitutional duties. So if he had to consider that as part of his job, I think that the criminal statute, they're saying hey, listen, that's a criminal thing. You probably can't rape people. You shouldn't do that. That would be a good amount of caution to have him consider, right? Okay, well, fuck, if I do this, it's actually against the law. Maybe I should consider that, But I could also think of some things that are unduly burdensome that you wouldn't want a president, for civil litigation, I would agree. You don't want a president okay, fuck, we need to do COVID lockdowns, otherwise the country will fall apart. But if I do this, some business owners might sue me personally. I might get fucked, right? I can understand the civil immunity. It makes a lot of sense. I don't know as much if I agree with the criminal immunity, except in some cases, but we'll get there, I guess. In Nixon v. And then one question, I see this typed in chat a lot. I don't have a strong opinion yet, but one thing that keeps coming up is Watergate. Would Nixon have been liable for Watergate under these particular, under this interpretation of the court as criminal immunity? But who knows? We'll see.
I mean, I would think so, because in that case, he was bugging the offices of his political opponents as part of a campaign. So I'm not
sure.
So
one thing, so the
presidential duty.
I understand what you're saying, but so this is where the really confusing part comes in, right? I don't know any of the details of Watergate, but let's say that Nixon requested his FBI to investigate and had the FBI go and bug it. That is literally a core power of the president that would, by this court's argument, be beyond review or consideration. So how would you even call that into question? Because it seems like it would be beyond.
Absolutely wouldn't, and that's a great thing to identify, Stephen. Keep in mind that Nixon was being investigated more for the obstruction component than necessarily being involved in the robbery itself. It's more of the crimes afterwards, where he recruited members of the actual government, right? The White House counsel and others. And so I don't see why Nixon's did anything wrong under that standard. And certainly if he directly ordered.
Sure. Or careful, not even, we wouldn't say he didn't do anything wrong, but he didn't do anything reviewable, right? So whether it was wrong or not, we have no way of even knowing, right?
If you are absolutely immune from something, are you doing anything illegal?
Well, not illegal, but wrong. I'm just saying because you said the word
wrong. You can't be punished for it. Right?
Yeah, you can't be punished for it.
And this is where, by the way, all of the hypotheticals about SEAL Team 6 and assassinations are absolutely on point. If you notice the example used by the court of a core executive power, it is the communications that the president has with the Department of Justice.
Yeah, sure.
If the president ordered an individual in the Department of Justice to kill a rival, that would be the same kind of communication. What would be different about that communication that would be amenable to criminal process and indictment?
Sure.
There's absolutely no way to distinguish it.
Do special counsels, are those always at the discretion of the DOJ, or can there be a special counsel that comes from Congress?
There's a case called Morrison v. Olson, which had to do with the independent counsel statute, but that's been phased out. And that was still part of, as interpreted, still part of the executive branch, just not like immediately fireable by the president. And there was other layers of review, but nowadays all special counsels are employees of the Department of Justice and are bound by their policies and can be fired.
Gotcha. So then under this for core powers, basically any communication or any appointments that the president makes in the executive, we would say is probably a core power, right? 100%. So if the president felt like he was being investigated unfairly by any part of the DOJ or any part of he could very easily just fire and remove, like explicitly say, he's like, I know you guys are investigating me, like you're all fired and I'm bringing new people. And that would be unreviewable by any criminal court, right?
Yes. Evidentiarily, it could not be used to establish other crimes, and it itself, you'd be immunized from it. And if you had any kind of like helpers or accomplices, obviously you could pardon them to the extent that they were committing federal crimes. And if he were impeached for those efforts and removed from office, he still wouldn't be amenable to criminal indictment. That's more immunity than Trump was asking for. This court was reviewing Trump's ridiculous argument under the impeachment judgment clause that in order to indict him for official acts, they had to first impeach him and then remove him. They went one step further than what Trump asked for and said, even if you impeach him, even if you remove him, you cannot indict him for any official acts. And those can be as broad as using the bully pulpit. You see them considering like just general public statements to the public as being contained within, or possibly contained, conceivably contained,
if you're
official action. It is so broad. It is insane.
How do you get rid of a federal judge? Is that a executive power or congressional power, or
impeachment?
Get rid of a judge, you'd impeach him and remove him.
So for federal judges, so when you say impeachment, that it has to be through Congress, basically.
That's correct.
Yeah. Okay. All right.
And
I think it's happened like 9 times total.
Okay.
One other thing. Notice there the total lack of coherence in this theory. The opinion goes out of its way to say the president is a branch unto himself. He is the executive. That's a unitary theory of executive power. If he is the executive branch and the executive power, it's all part of his power, why doesn't this immunity extend to every member of the executive branch? Why is it that the president is the only one under this theory that has absolute criminal immunity to this extent? Why wouldn't that apply to every other member? Maybe because there's zero history and tradition.
That's the wrong way around, I think.
No. Because think about it. If the executive branch, if he's a branch unto himself, how can he give away less power than he has? How can he give away or delegate some power, that's separate from the nature?
Or we already have like a structure for this, right? You would just say that any person that's acting in the branch would always just say like, oh, well, the president ordered me to do this. And then that would essentially make it beyond review, right?
And the president's authority contains it must. Why wouldn't it contain all of the protections of the president's authority?
That's not quite right, because most of the executive is delineated by statute, at which point you're in a slightly different category because it's not a core constitutional interest. So if you're just talking about an employee working in a random agency, that agency exists because of a statute, not because of inherent power of the president.
The DOJ exists by virtue of its statute, and notwithstanding that fact, when the president makes orders to the Department of Justice, that has been described as a core executive power.
When he's talking to the attorney general, who is a senior advisor, at least, yes.
Well, hang on a second. But you agree the attorney general is a creature of statute. His authorities are made from an act of Congress. And so it's not this constitutional statute distinction, because what has been described as a core feature of the executive power has been communications to a statutorily created agency, namely the Department of Justice. And so I have no reason to think that like the basis of distinguishing the authority here is between statute and constitutional authority, or it's so broad under the take care clause or the general power of the executive to remove his officers, that it would encompass any communication or any action within the executive branch. There's no theory here. There's no history here. There's no text in the Constitution that references absolute immunity. These were smart guys, these founders. They knew how to write immunity clauses. They already wrote immunity clauses. They knew how to do it. And this court has abandoned its analytical framework of supposed textualism, supposed originalism, for results. It wants to protect Donald Trump, and so that's what it did. And it's made a road to authoritarianism and tyranny, frankly. This is a really bad ruling. It's horrible. And anyone who defends it doesn't really stand for American principles.
Well, I appreciate being thrown under the bus that hard before I could even offer a contra idea, but okay.
Well,
but I will note that the
ruling?
Well, let him.
yeah,
we'll
if I believe the ruling is correct, that I don't love America is a pretty harsh position to put me in right from the start.
Well, I guess I'm asking you a direct question now. Do you support this ruling?
In large parts, yes, but I'm still vague a little bit on the middle part, as I expressed earlier.
That's not good enough for me.
Well, that's tough because I don't have a firm position yet. I haven't thought it all the way through, man.
If you're equivocal about whether or not you think the president of the United States could have this level of immunity, where essentially all he would have to do is very easily come up with some official act intermediary. And I can't think of where this ends. Honestly, think about it. If you had an order, I order my FBI agent to go and sexually assault someone, and that act itself, that ordering of the person to go do a most heinous act is unreviewable. Where does it stop? Where are these pro forma excuses that, oh, this is law enforcement purpose, this is national security purpose? This is the stuff.
Well, here, let him answer. What's the answer to that?
Well, I mean, there's a couple things that I have to respond to. With respect to the idea of the Attorney General, I will note that the Constitution does designate the idea of principal officers that the president has the ability to appoint. So there is a difference in the Constitution between, for example, the Attorney General and just a rank person who exists at the DOJ. The Constitution does treat those differently. With respect to the idea of immunity, then you're correct that the Constitution doesn't say that. And even the Supreme Court points that out, that it doesn't say that. But they're concerned about the power and separation of powers.
Wait,
I'm sorry?
They're concerned about policy.
Okay. I will simply note that I let you speak for quite a while.
I apologize.
You interrupted me.
Yeah.
Okay. So we can press on to other things because I lost my train of thought.
You lost your train of thought. You're defending absolute immunity. You were in the middle of saying that.
First of all, no, I wasn't, because as I said at the very start, I'm a little unclear on the middle part with respect to the official acts as opposed to core acts. And then you said that wasn't good enough.
Well, so here's like the question I guess I would have for you. So we agree then. So we're going core Constitution, right? The Constitution itself spells out that the president shall appoint an attorney general, right? We all agree with that, right?
So it says that he appoints principal officers, but I don't know why that's a distinction that matters.
I'm just laying out the core just so we're on agreement here, right? So we agree that the president can appoint an attorney general, right?
That's correct.
We agree that the Department of Justice exists, that the FBI is a part of that, right? If the president himself, so the first question, if the president himself goes to the attorney general and he has a conversation about how to enforce the law, or a conversation, I guess, really at all with his attorney general. And in that conversation, he says, hey, I really don't like civil rights. I want all of my FBI officers to every single black person that they see. Okay, that's a new thing I want, right? And then let's say FBI officers start doing that. Obviously, the Congress, they start getting in trouble legally. And then somebody says, well, where did this come from? Do you agree, two parts? One, that the president was performing a core function of the presidency, and that two, it shouldn't be criminally reviewable? Or do you think there's some way, looking at this Supreme Court decision, that would allow you to review that decision for uncivil law?
I would say no, because I don't see how the president is chief executive, has the ability to enforce the law. So I'm not sure how that order would be.
Wait, you don't know how the president has the ability to enforce the law?
Wow, amazing. I got 5 words in and I got interrupted again.
Hold on.
The question was asked to me, Pisco.
Yeah, wait, okay, hold on. You're saying that you don't understand how that order would be enforcing the law, right?
No, it wouldn't be enforcing the law because it's not part of the function of taking care that the law be faithfully enforced to give that order to an FBI official.
But are we able to review?
It's for the law enforcement purpose.
That is preposterous. So the president of the United States absolutely enforces the law. He's the chief executive.
I know, I said that.
Okay, so when the president makes an order, are you suggesting that that doesn't have the force of law or isn't pursuant to his duties under the take care clause?
No, not necessarily, no. Because just because he has the power to order the FBI to do things that would be part of taking care doesn't necessarily imply that every order is part of that function. He could give obviously something that's completely not part of that function.
Okay, wait. So wait.
An FBI official to do act.
Yeah.
He has to be amenable to law.
Wait.
That
Okay.
means-
I hold on. I think that's a good point. But how can we even begin to distinguish if his decisions aren't able to be reviewed?
Well, the Supreme Court does talk about the delineation between official acts and unofficial acts, which they spend much more verbiage on.
What do they say?
This is official. This is a core function. You're ordering the FBI to do mass. That's an official.
No, I don't
What's
think
the
that's true.
about that?
Because just because it's being done to the order is given to the FBI official doesn't mean that the order is part of the core function. I mean, to put it more plainly, if the president gave the order to the FBI official that I want you to go stump for me and give political speeches for me, I don't think anyone would say that's part of the core function of the president.
Yeah. Okay. Wait. Wait. So
FBI.
yeah. I think I agree. I don't know if Pisco agrees or not. I agree. But under this ruling, how would you even make that determination? Who makes that determination if you're not allowed to review by virtue of the relationships, like anything that's even ordered there?
Well, they spend time talking about the delineation for this issue and the issue versus the communication to the DOJ versus the communication to subordinates has a delineation here.
Sure, but I'm not talking about that. No, very, very clearly. And I'm not asking for you to say that they discuss it. I want to know, either you can tell me what they discuss or what they answer. How would you do it? I see that all over the state that I live in, FBI agents are running around people. And then there's a leak that comes out, somebody recorded with their iPhone 15 Pro, the president talking to, his new attorney general, Sidney Powell or whatever. And he's saying like, make sure to get this done or whatever. We want them all raped or whatever. And I go, hey, this is obviously criminal in nature. How do you even begin to probe that when the court says, I'm sorry, but the president of the United States, in executing the laws of this country and communicating with his attorney general, this is a core function of the president. He's literally speaking as president to ostensibly to enforce laws to his AG. How do you review it? Where do you get the test from here? Like, what do they say in this case? I haven't read far enough. Do they address that? Because it seems like the answer would always be, sorry, that's not reviewable, bro. This is literally the president's core job.
I think the verbiage in the case does try to delineate that, and
how?
It's not as clean.
Well, no, I'm asking how. You keep saying they do it. How do they do it? What is the delineation? How?
Let me pull up the opinion, and I'll get back to you on the language.
Okay.
Well, just to state my opinion, I'm just going to say it. Like, it's horseshit. There is no delineation here. It's absolutely a core executive function to order your, or to have communications with the Department of Justice. That was the example they used of Trump like talking to his DOJ and starting these bogus investigations based on corruption. And if you want to say like, okay, mass rape, that's not clear or whatever, fine, I can change it up. I'm not going to let you dodge the hypothetical.
We can say mass arrests or whatever, right?
Well, going further than that, you agree, I'm sure, because you won't deny it, that one of the FBI's jobs is to stop terrorism. And in the effort of stopping terrorism, you kill terrorists who are imminent threats. And so the president issues an order to an FBI field office or to its head. If you want to make that little principal inferior officer distinction, I don't care. The order is brought from the president, and he says, I want you to kill a terrorist. The terrorist is threatening the country. That terrorist is an imminent threat, and that terrorist's name is Nancy Pelosi. Unreviewable. Absolute immunity for that action. And don't tell me it's not a core function to order the FBI or to order the DOJ. And don't tell me that stopping terrorists isn't a core function of the FBI.
Okay, I won't tell you that.
Well, hold on, wait, real quick. Also, just somebody in chat says,
how do you support it?
What's Pisco's rebuttal to yes, there's no criminal recourse. There's political recourse through impeachment or the voting booth. These are criminal consequences for something are not the same as an electoral consequence. Nobody's talking about an electoral consequence. We're talking about whether or not somebody should be above all forms of criminal prosecution. I don't know why you keep bringing that up.
And if you want to keep having elections, chatter, one way to do that is to make sure that you don't make a rod for your back and have these court rulings that open the door to tyranny, to people who literally try to steal an election. Your country, your Department of Justice is trying to enforce the law as against someone who tried to steal an election. And the Supreme Court says it doesn't matter if you try to coup d'etat using the military, because if you try to coup d'etat using the military as commander-in-chief, that's a core executive function. And as long as he made the order to his junta, that's unreviewable. You can't use it as evidence. And the act, you have absolute immunity for it. What is this bullshit? What is this equivocation that I don't know if I like, I don't know if I read it. You don't even need to read 100% of it. I've read it, but you don't even need to read it to know it's un-American. This is bullshit. And you shouldn't stand for it and hear these kind of like, I don't know, oh, it's not as bad as people say, it's whatever. No, this is bullshit. It's un-American. And anyone trying to gaslight you and say it's not is lying to you.
Do you think they're lying, or do you think maybe they just disagree with you?
They're lying to you that this is not a significant grant of authority and immunity. I mean, it gave Trump everything he wanted and more. It effectively, it's limitless and potentially in its scope. Think about like what really would be an unofficial act for a president. If you like driving a car around, you can say I'm driving because I'm going to go meet some voters, because I'm going to, this is part of me doing my bully pulpit. I mean, I struggle to think of any action one could take that he couldn't trivially turn into an official act. It is gross that anyone could be defending this on any ground. I mean, and to think also like that's just kind of like what it feels like, but now put inside the analytical components, the analytical pieces where look at this hypocrisy. For years we've been talking about textualism. Where's the textualism? There's no immunity text. Where's the history, right? All of a sudden, right? We don't have a storied history of absolute.
Well, the history are a couple of court cases against Donald Trump, apparently.
The court says, what would we do if these presidents are chilled from all this criminal? Guess what? This presumption has never existed until now. This is the first time anyone.
Which I think is the problem. They're trying to be forward-looking about this a little bit because they're worried about what does happen in the future. Which the Supreme
Court. But this is a consideration that I hope is addressed in here. But they keep talking about the idea that like, well, if this consideration is a new thing going forward, it might have a chilling effect. Well, do you think there might have always been this consideration? Like here, this would be a question I have. Again, I have only read up to 19 pages of this, but like, if Nixon would have gone into the future and read this decision, would he have even bothered resigning? Like what? Like why? If he felt like he could fight in court, like is it not possible that this chilling effect has not only already existed, but maybe it's a good chilling effect that some people don't think that they're above all forms of criminal prosecution? Like maybe that's a good thing, and maybe people have already been acting like it. Like this is something that I would want to see for a historical analysis. I would want to see conversations, and I've already seen some by Jack Smith because he put it before the federal court for his indictments, that it feels like when you read, especially about Nixon, I mean, it's our most related example, that there was an assumption that presidents could indeed be criminally prosecuted. And that was something that they were operating under. I would be curious to see if under Nixon, if there were arguments at the time of people saying, oh, no, Nixon will probably be fine. Don't even bother pardoning him. Like, we already know that presidents have unlimited immunity when they're doing things that are even on the outer perimeter of their actions. Like, he'll be fine. Like, just fuck it. Did that discussion ever happen? Yeah, go ahead.
I think the outer perimeter is at least partially an answer to some of Pisco's concerns, because I seriously doubt that you can make a credible argument that the FBI ordering, the mass sexual assault of people is within the outer perimeter of his.
Take the killing.
Sure. Wait. We don't even have to use a hypothetical here. What about Donald Trump going to Mike Pence and saying, "Hey, I don't want you to count these 7 electoral slates. I want you to count the illegitimate ones that I did instead." That's absolutely a core power to discuss.
No, they disagree with you. They thought that it was more ambiguous than that. In the decision.
Wait, are you sure? I thought that they explicitly called that out and said that this was a core power for.
They said the DOJ one was, but they said the Pence thing was more ambiguous.
It's about like whether or not that it's a close call, that like he could be exercising his legislative function as the president of the Senate, and so perhaps those communications. I mean, like, what are we talking about here, right? Look at the formalism that the court is willing to go through to try to like.
Just as a real quick thing, conversations between Trump and Pence about their official duties, that is presumptively immune from prosecution for such conduct. So the government has a burden to even prove that they have to rebut the presumptive immunity to even begin to probe that for the conversation between Pence and Trump. And that was even given the indictment was true, given all the facts were true. That was in the initial outset, whenever the president, so
Yeah, they want the lower courts to analyze it in a more detailed way. So they weren't able to say as a categorical matter. They wanted a more nuanced consideration of the degree to which it was official versus unofficial
Yeah.
acts.
Sure,
And
but
good
if the
luck
court's
with that.
been
I mean,
this like generous in how it sees things to the president, like how generous are they going to be for what counts as an official act? Like if you were willing to rule this generously right now on all this immunity, like I feel like because if their argument is, well, it can't be something that's going to unduly burden the executive. I mean, if the president or an ex-president is saying this would unduly burden me, and if that's the argument they're making, I mean, like Jesus, it seems like what wouldn't burden an executive here? I don't know what the threshold is, but maybe they give a good test for it, and I'll see it later on in this ruling. Maybe.
and you can come with a thousand examples that go to core executive function. That I mean, I want answers from like about one of them, uncivil law. I'm sorry to be a dick. I just think I love this country, and I think that this ruling.
I love this country
is-
too,
I-
whether you
I-
believe that or not.
Well, then I feel really upset that you would be like somewhat okay with this. I think anyone who loves this country needs to recognize what an aberration this is. And we can run through a trillion hypotheticals, a trillion hypotheticals where, I don't know, you ordered the DHS to deport a U.S. citizen on purpose to Mexico. Or that's core. You're ordering an agency. You're ordering them to do something in their power to deport. You're doing it on purpose. You're deporting a U.S. citizen on purpose to like throw him out of the country to like, I don't know,
Yeah.
to drug land. How can this be that the president can so easily be above the law? Even if you say, oh, there's technically maybe some areas where he might not be, it's trivially easy for him to be above the law. That should tell you something, that just by corrupting his own administration, that's the best way to get away from criminal liability. That's the incentive structure.
It may be me mishearing it, but I understand that as more of an emotional appeal by looking to the potential horribleness of the consequences rather than a straight legal analysis. Because if you assume the premise that the correct legal answer is this, then that's just the correct legal conclusion.
Well, hold on, wait. I would say
horrible conclusions, but that's the correct answer.
Well, I would say,
start with
wait, real quick, to be careful. It's not just a strict legal thing. Like part of the legal consideration, or you can say it's a strict legal thing, but part of the legal consideration is this going to be an undue burden on the executive? That's part of the consideration.
Yes. So absolutely true. What Stephen told you, and what's clear from the opinion is that more than anything, the court is citing like what it thinks are going to be the consequences and what's going to burden the executive or not burden the executive. And so I think if you're doing that, consequences are fair game, and like you can go over that. But I don't even need to go there, because as with all like legal things, we start with the text. Okay. Is there any immunity clause in the Constitution? No. There is no immunity clause in the Constitution. Okay. Now let's go look at the history, founding documents, legislative history. Is there any Federalist paper, communications at the time of the founding, discussions about what absolute immunity is, discussions about core executive versus no, there's nothing, absolutely zero. Is there any like historical practice where there's a letter where Abraham Lincoln says, I am criminally absolutely immune, where they use these terms, or any kind of practice whatsoever? No, there's none. And so when you start talking to me like, what's the legal analysis? What's the legal analysis for assuming that a provision that doesn't appear is real? I can grant you that there could be certain congressional statutes that are incompatible for like with the Article 2 of the Constitution. Like I would agree that like if Congress purported to criminalize the president's ability to make a pardon, I would be like, yeah, it's unconstitutional under normal separation of powers principles, not under immunity. You don't have to invent an immunity doctrine for that. You just say, this law as applied, violates the Constitution. Why you have to invent this immunity structure? It's totally made out of thin air. It's bullshit.
What's the practical difference between saying there's immunity versus the law's unconstitutional?
A lot of practical differences. So number one is you don't have this like ridiculous evidentiary thing where, we can't consider your intention and motivation. That's Looney Tunes. Of course we consider people's motivations when we're determining if something's official or not official. If I talk to my DOJ like about getting into my pool, that's a conversation with the Department of Justice. But like my state of mind, what I'm like, the nature of what I'm saying, right? Like you have to consider people's intentions, whether things are sham, to understand if it's official, right? Otherwise, anyone could just put something in a memo and all of a sudden it's official. If you're not really interrogated and taking a second look at the shamness of it. And so because absolute immunity doctrines are by their nature, they don't want to do that, because by doing that, now it's just ground down into like the actual crime itself. And so the whole immunity is obviated if you need to have a trial about your intent level, and then just like the sphere of immunity overlaps with the underlying criminal conduct. And so this gets rid of that bullshit, number one. And then number two, practically, we can have trials and we can discuss whether it's unconstitutional after the application of those, like we do for every other criminal defendant in this country. It's every other, and that's equality under the law, right? If there's something that's unconstitutional under state law, you try at the trial level, and if it doesn't work, you appeal after the trial. That's almost always how it works. But
yeah,
no,
but if we take the pardon as an example, suppose Congress just passes a law that says it shall be illegal for the president to pardon a non-citizen, and the president pardons a non-citizen, and we put him on trial. Are you trying to say that there shouldn't be some sort of motion to dismiss?
There should be a motion to dismiss. There should be a motion to dismiss on the front end. It should be granted. But if it's not, and again, different jurisdictions might differ on their rules for interlocutory appeals, I suppose. But at the very minimum,
this is federal, so hopefully it's uniform.
Hopefully it's uniform. And I think there'll be. I don't actually know the interlocutory rules for appeals. It's somewhere. You guys can look it up. But whatever it is, like, there is a practical difference to an immunity doctrine versus just ruling things are unconstitutional. And the proof is in the pudding here. They went with immunity, and you see the consequences of it. And you see, my world is completely different. In my world, we're not having this conversation of these ridiculous hypotheticals, which I'll note you haven't been able to address, right? Like, you haven't been able to address the ordering of the FBI to kill a pro forma on paper terrorist named Nancy Pelosi. Like, there's nothing that you're going to be able to provide about that situation that distinguishes it from.
Okay, Uncivil Law gets a response, and then I get the. And then I'm going back to
which kind of tries to deal with this. I don't know that you will find it satisfactory, but they try to address this delineation about official versus unofficial responsibilities. And they talk about, for example, at the bottom of this is PDF page 25, marked page 17. At the bottom of the page, they talked about immunity extends to the outer perimeter. They're not manifestly or palpably beyond the authority. I was thinking you're hypothetical that you could make a pretty credible argument that would not be within his authority.
Okay. Last thing I'll say.
Yeah, go quick.
I'll submit that whatever manifestly not within the authority is true here, as it is in that hypothetical, and that's all I'll say.
Okay, love you. All right, jeez. If official conduct for which the president is immune may be scrutinized to help secure his conviction, even on charges that purport to be based only on his unofficial conduct, the intended effect of immunity would be defeated. I feel like we should have examples here. I wish he would give examples. I could think of some, but I wish they would give some. Use of evidence about such conduct, even when an indictment alleges only unofficial conduct, would thereby heighten the prospect that the president's official decision-making will be distorted. What he's essentially arguing here is he's saying, okay, well, listen, if you're going to give immunity for these actions and everything that he does in those actions, you can't, like, subpoena those actions and then use them to indict him on something else. So, for instance, what they're saying is like, okay, sure, let's say the president accepted a bribe here, but the only proof that you have of that bribe is him telling his attorney general, hey, listen, like, let's say this, okay? The president says, hey, Will, I want to promote that FBI agent if you give me like $1 billion, okay? Give me $1 billion and I'm going to promote this FBI agent or whatever. I'll send a letter and I'll do that shit, blah, blah, blah. And then Bill's like, okay, yeah, hell yeah. Let's say then that FBI agent gets a promotion and every single person in the office is like, wait a second, what the you just promoted this guy for no reason. Why? And then someone's like, holy shit, I just heard... I heard Donald and William chatting outside. He said that he was going to promote this FBI guy because Will is paying him off, right? Now, if you want to take that to court, you go to court, you go to a judge and you say, listen, we believe that a big bribe has happened, okay? That somebody's been promoted. Now, listen, we're not questioning Donald Trump's ability to say whatever he wants to William Barr when they're talking about this. That's fine. He can do that. He can say whatever the he wants. But the promotion of this FBI guy, we know this is illegal. We know this is a bribe, okay? So we just want to subpoena or we just want to like enter into evidence that conversation, okay, just to prove that this other crime is done. We're not criminalizing anything he said there or anything that, we're just to prove this other thing. Then what the Supreme Court is saying is like, no, because if you do that, you're getting around the immunity by still finding a way to scrutinize that to convict somebody else or whatever of another crime, right? Maybe the person being convicted of the crime isn't even the president, but they're saying that the ability to subpoena or have somebody under immunity have to submit evidence for an unrelated crime is still violative of that immunity. Therefore, you can't even subpoena or ask anything about stuff that is within the thing that we would consider absolute immunity. I don't know if any other immunity works that way. That argument to me is not very convincing because it seems like it has a whole host of things that are a whole host of bad implications. But like, yeah, like I'm just trying to think of like if Bill Clinton would have said things about Monica Lewinsky, I feel like there are arguments that you could make here. If he were to try hard enough, that would just make it like you can't review this decision. Like it's just, I don't know. That just seems wild to me. But
a question for you, since I'm not going to be able to listen to the whole thing until August post the VOD because I'm about to leave. But what do you think so far, based on what you've read? Is it as bad as what it could have been? Is it worse than what you thought it would be? What about this opinion?
I feel like it's worse than it's hard to say yet. I feel like it's worse than what people worried about initially. That's the feeling right now. But maybe as I get through more, maybe they'll hedge somewhere where I'll feel like it's not quite as bad as it seems. But it seems pretty bad. It just seems like a very bad ruling. But I don't know.
Yeah, I mean, you obviously you highlighted a lot of the things that a lot of us took issue with. I mean, number one, for me, the first and foremost, there's just no textual or original basis for this. I mean, the thing they keep going back to, they appeal to this idea that, the founders and framers envisioned an energetic and vigorous executive, but doesn't that seem to imply like the only way you can have that is if you afford them absolute immunity? But I don't see why that's the case.
It's not, remember, it's important when people are lying to you, if somebody's like doing some weird shit in real life, it's not always important to look at what they say. It's also important to look at what they don't say or what they don't do. There is no immunities clause written for the president. Mm-hmm. There is no immunity anything written for the president.
No, you're right.
Like, it's just, it doesn't,
doesn't that imply that the framers, even if they did intend for a vigorous and energetic executive, which I don't dispute, I don't think anybody does, I think they intended for the president to be the most powerful individual in government.
Yeah, he is vigorous and energetic because of the powers granted to him, not because of immunity to criminal prosecution. Like,
the other thing is, do you buy the, he says, Robert says, I think you'll get to it later, where he basically chides Sotomayor and Jackson and Kagan. He's like, listen, they're freaking out. They're using chilling rhetoric. It's not that bad. We distinguish between absolute immunity and presumptive absolute immunity. But I'm having a hard time finding a meaningful distinction there. If you can't examine the official acts themselves, if you can't examine motive, I don't know. We're getting to
that. I'll see how they balance that. But yeah, presumptive immunity just means that it's an act that the president or it overlaps with some other body in terms of what that could do that act. So in there, the government would have to prove that he's acting. What do they have to prove to get over presumptive immunity? Do they have to prove that he's acting in an unofficial context, or do they have to prove that?
Yeah, right. That they have to prove that he's acting outside the scope of his official capacity. And I think the line is the president acts in a way that's not manifestly or palpably beyond his authority. Basically, if he is not completely out of left field, he's taking official action. And I'm just that's where, to me, it gets into the absurd hypotheticals. How could you possibly, how could you not possibly make the argument that ordering assassinations or staging a coup, if he interfaces with the Justice Department or the military, that is palpably within his authority.
Sure. Well, I mean, but they said that. So, for instance, they remand the lower court on a couple factual things to determine if it would be presumptive immunity on some things, and then they remand the court on one thing to make a determination of like the Pence part on whether or not the president was acting in a private capacity there. But they say that the conversation between Trump and the attorney general, where he threatened to fire the AG if he didn't write fake letters to the states, that's a matter of absolute immunity. So that is off the table now from the Jack Smith indictment. That can no longer be considered according to the Supreme Court decision. That has to be tossed completely, all of that and everything related to it. Yeah.
So I'm saying, like, how is it that like anything? Because my understanding is part of the reason that they are willing to remand the vice presidential aspect back to the courts is because the vice president has dual purpose. He is both an executive branch employee under the purview and authority of the president, but he's also president of the Senate, right? So he's like a legislative officer as well. And with respect to pressuring Pence to try to overturn the results of the election, Pence was acting in his capacity as an officer of another branch. And so it's just like, okay, let's say we grant that. And even then, by the way, it presumes immunity. So the default is he's immune. The government has to overcome that burden.
Yeah.
But set all that aside, let's say that we take that as a win. The executive branch is it's the biggest of the you're talking about the attorney general, the joint chiefs of staff, any military officer. Like I guess I don't take much comfort in them saying like, hey, there's a sliver of a possibility that the stuff with Pence might not fall in the scope of absolute immunity. And I don't think they provide a test in the majority opinion.
That's what I'm looking for. Is I'm trying to figure out how they're supposed to even make that determination of what that test even looks like. So I don't know if they're expecting a test to be developed in the lower courts or what or how. I don't know, but we'll get to that, I guess. Yeah.
Yeah. Last thing I'll say is I saw your on 1.75 speed your conversation with Piers, and again, buddy, I just think you killed it. And the exchange, I love the fact that you called him out. Like, listen, while we're having this conversation right now, 4 or 5 days later after Biden's shitty, debate performance, right now we have this major Supreme Court decision and nobody's talking about it. And I do think you tripped up Michael Knowles at the end there did you ask him something to the effect of how could the president ordering an assassination not be counted as an official act? Because he said something like, well, it doesn't say that the president's above the law. It just says he has absolute immunity for official acts. And when you asked him to show like how that's not an official act, he stumbled. So
yeah,
they give the game away. Like they know this is de facto sovereign immunity for all intents and purposes.
It seems like it, but who knows? Yeah, we'll see.
All right. Well, good luck, buddy. And are you going to read the dissents? Because I think those are also worth.
Yeah, goal is to read the entire thing. Yeah.
Cool. All right, buddy. Talk to you later.
Be careful.
Destiny, you would vote for Joe Biden's urn with his ashes.
I would. I did say that. If they brought his urn up, I would vote for it. Hell yes, I did.
Rather than Donald Trump. Destiny, you would vote for Joe Biden's urn with his ashes.
I would. I did say that. If they brought his urn up, I would vote for it. Hell yes, I did.
Rather than Donald Trump. When you and Destiny basically agree, that's when you know how bad this situation is, right? I just want to bring in Fox News medical contributor Dr. Mark Siegel quickly. Dr. Mark, great to see you. And the reason I wanted to talk to you was because we've got a clip. This is Biden debating before the 2020 election and Biden debating now. I want you to watch this and just give an assessment of what we think may be happening here.
I'm not here to call out his lies. Everybody knows he's a liar.
I just gave $28 billion to our farmers.
Taxpayers' money.
It's what?
Taxpayers' money.
You can see he is 6'5" and only 223 pounds, or 235 pounds. Well, you said 6'4", 200. Well, anyway, that's what anyway, just take a look at what he says he is and take a look at what he is. Look, I'd be happy to have a driving contest with him. I got my handicap, which when I was vice.
The funniest thing is, I don't even think this is the worst clip of Biden for the debate. I think there were a couple of clips you could choose that were way worse than this. Nobody talks about it because it's a big meme, but I thought the funniest moment was, what did he say? What did Biden say? Like, we went to war with the elderly, or like we eliminated Medicare. He says he said a couple of wildly stupid things.
Vice president down to a 6.
We defeated Medicare? Yeah.
I mean, I play golf off 16, and I've said this before, and I'll say it again. I would bet $100,000 to a charity of President Biden's choice that I could give him a shot a hole rather than him giving me 10 shots. and I'd still beat it. This idea he was ever a 6 handicapper is ludicrous. But Dr. Mark, there are so many clips that people are comparing to 4 years ago to 8 years ago of Joe Biden in debates where he sounds previously whip smart, really on it, dynamic and so on, eloquent, articulate. That person no longer exists. What is likely to be happening here?
I'm glad you used the word likely, because obviously I haven't examined him, but Piers, first of all, everyone out there needs to know that he's going to be the last to know. Any neurologist will tell you he's going to be the last to admit it. Those around him will see him faltering. They'll see him having problems with speech, searching for words, not following a sentence from beginning to end, saying ridiculous things, saying offensive things, getting irritated when he's contended with. That's a sign of growing cognitive impairment. He's going to be the last to admit it. And then his wife steps in and starts speaking for him, reminiscent of Woodrow Wilson, when he couldn't rule the country and his wife was taking instruction and running the country. That was probably the scariest thing of all. I think that there's a lot of risks he has here for dementia. One, he has an irregular heartbeat, and that irregular heartbeat can lead to silent ischemia, silent strokes. He walks with this gait that looks neurologic to a lot of neurologists, that there's a problem with his gait. That goes back to what's going on up here. Does he have fluid on his brain? Some neurologists have said he could have an atypical Parkinson's. He's got something going on. And here's something that none of your expert panel yet said, and they're expert. I love this panel you have. Piers, never mind whether he's going to run or not. Can he be president now?
Right.
He doesn't have cognitive reserve. What happens if we get a phone call in the middle of the night, that famous phone call in the middle of the night? There's a nuclear threat going on. You want this bumbling idiot to actually address that? And of course, you know, Tomi was right. The world leaders are watching this, but how about our own national security?
Yeah, well, I was struck by the briefing that came out saying, you know what, he's pretty good between like 9 and 4 o'clock, which is why all the clips of him out there speaking, like the next day he was out and sounded pretty different. And I was like, well, that's fine, right to the point that he has to apply his finger to the nuclear trigger at 6 o'clock or 9 o'clock or midnight. I mean, if we get the guy who was on that debate stage at the wrong moment, I wouldn't trust him to run a bath, let alone run a military order.
That's a great point. You know, if he's sundowning, he can't run the country after 6 p.m. And then the White House is saying he has a cold. Well, excuse me, I've had colds and I still can carry a train of thought. Cold medicine. I take Dayquil sometimes and I'm fine. I can think clearly with Mucinex. I mean, whatever they gave him, if it impairs him to the point where he can't speak clearly or think clearly, he can't run the country.
Mark, is there a mechanism under... If it turned out, for example, that he genuinely has got a deteriorating dementia that is quite aggressive, and this gets medically diagnosed now as a result of this debate, is there a mechanism for his removal that you're aware of from the office of president? I mean, 25th Amendment, does that cover it?
Yes, the 25th Amendment covers it. And to your point, I want to point out that his last physical that he had in February, I have been asking for years now, and Tomi, the same thing. I've been asking for years now for a full assessment. They didn't give it. They danced around it. No MRI scan was listed. A lot of dementias would show up on an MRI, and no formal cognitive testing has been done. I think there could be a demand for that right now. What does his MRI show? If he's impaired, then there would be a case for removing him now.
Yeah, I completely agree. Dr. Mark, always great to have your contribution. Thank you very much indeed. Destiny, you were chuckling there. What were you chuckling about?
The idea that a Republican would demand a full physical assessment from a president when they wouldn't even demand Trump's taxes is hilarious to me. The idea of not being able to answer the call in the middle of the night, I mean, it's already happened. We've had it with Ukraine. We've had it with Israel. Like Donald Trump did not show leadership when Iran attacked Saudi Arabia and he stood by and did nothing. He didn't show leadership when he abandoned our Kurdish allies in Syria for absolutely no reason. Biden has shown leadership, whether you like it or not, whether you like how he's dealt with it or not. He has shown leadership and the ability to bring allies together for Ukraine. He has shown leadership and the ability to force Israel to simultaneously show restraint while still remaining faithful as an ally. So, I mean, like, we can make fun of a debate performance all you want, but we can compare the legislative records of both presidents and we can compare their actions in office.
You can, but here's the problem. Yeah, but just to me, you can, but here's the problem with that. is that it's just not cutting through. There's no doubt Biden's had a number of wins as president. No doubt at all. There's no doubt that comparative to most of the rest of the world, the US economy is purring along quite nicely.
Bullshit, and Dusty knows it. See ya forever. Bye.
But his approval rating is at 37%. And after that debate, this issue of his own ability to function physically and mentally is now the only thing anyone's going to talk about for the next 5 months. He was incapable, when it really mattered, of articulating to the American people what his successes were, what his policy wins had been, what his attack lines against Trump were going to be, and why he should be re-elected. He couldn't. I mean, honestly, I watched the whole thing at 7 in the morning.
I understand that, but
hang on. I watched the whole thing at 7 in the morning in the UK until 8:30. I had a lot of coffee. I was about as alert as a human being could be. I barely understood anything Biden said in the entire 90 minutes. And by contrast, I've known Trump since 2006 very well. I've watched him at close quarters when I did Celebrity Apprentice for 3 hours a night across the boardroom, night after night after night, until, and modesty prevents me from going about this too much, until I won. But at the end of it, I had 100 hours of watching Trump. He's pretty much the same guy. You may hate him, you may hate the trash that comes out of his mouth, all those things. But in terms of his actual performance, Trump on that debate stage the other night, in fact, if anything, it was the most restrained I'd ever seen him. Because even he could tell the guy next to him was just melting down. So, Destiny, there's the problem.
Job is, Piers, after watching him? Did you guys figure out what a black job is?
I'm going to come to you in a moment for your analysis of what we think a black job is. But let me just get Destiny. That's what I think the problem is, right? The problem is that.
I understand what you're saying, okay? As somebody who spent the last 8 years cutting their teeth doing debate, that's what I do, is political debate. All I've heard every single time is debate doesn't matter. It's not that important. Now all of a sudden that's the most important role.
It does when it's that bad.
What about the immunity for criminal actions that Donald Trump just secured in front of the Supreme Court?
American people. Well, again,
thing that what we're talking about is Biden's debate performance over the legal request that Donald Trump is making.
Yes, but Destiny, but that's the problem.
This, that's what we're focused on.
But that
right, the problem. I agree.
But Destiny, right there is the problem, is that people are only talking about this. Remember, before the debate, 2/3 of all Democrat voters wanted Biden to stand aside because they were worried he was too old. What do you think they think now? No one's changing their mind on that. If anything, I'd be amazed if it's not 90%. And that's the problem. You've got so many things to attack Trump about, but nobody wants to hear it. When has Trump ever been in a debate where the next day the headlines weren't all about him? It's never happened. But now the only thing that anyone will look for with Biden in the next 5 months is him showing further evidence of mental and physical decline. Let me bring in Tomi. This is going to be...
All right.
Nearly 4 years ago, my predecessor,
for the White House where President Biden is speaking.
Courage to exercise the full power of the presidency. You also face moments where you need the wisdom to respect the limits of the power of the office of the presidency. This nation was founded on the principle that there are no kings in America.
Why do you look so unnatural while you aren't talking and have to look at the camera? Everybody looks weird. You're just staring at me because you're used to watching my stream where I'm not just staring at the camera the whole time. If you stare at any of the individual people here, you look really fucking weird just looking at the camera and doing nothing. I can't tell how autistic most of you are in chat. You're like, oh, you look so weird just looking at the camera. Yeah, that's what everybody does. That's what you do on these shows. You stare at the camera and you wait for your turn to talk. If you sit and stare at anybody, look at Tomi Lahren for the entirety of the Or look at Michael Knowles over here.
Each of us is equal before the law. No one is above the law, not even the President of the United States. With today's Supreme Court decision on presidential immunity, that fundamentally changed. For all practical purposes, today's decision almost certainly means that there are virtually no limits on what a president can do. This is a fundamentally new principle, and it's a dangerous precedent, because the power of the office will no longer be constrained by the law, even including the Supreme Court of the United States. The only limits will be self-imposed by the president alone. This decision today has continued the court's attack in recent years on a wide range of long-established legal principles in our nation, from gutting voting rights and civil rights to taking away women's right to choose. to today's decision that undermines the rule of law of this nation. Nearly 4 years ago, my predecessor sent a violent mob to the U.S. Capitol to stop the peaceful transfer of power. We all saw it with our own eyes. We sat there and watched it happen that day. Attack on the police, the ransacking of the Capitol, a mob literally hunting down the House Speaker, Nancy Pelosi. Gallows erected to hang the Vice President, Mike Pence. I think it's fair to say it's one of the darkest days in the history of America. Now the man who sent that mob to the U.S. Capitol is facing potential criminal conviction for what happened that day. And the American people deserve to have an answer in the courts before the upcoming election. The public has a right to know the answer about what happened on January 6th before they are asked to vote again this year. Now, because of today's decision, that is highly, highly unlikely. It's a terrible disservice to the people of this nation. So now the American people have to do what the courts should have been willing to do, but will not. The American people have to render a judgment about Donald Trump's behavior. The American people must decide whether Donald Trump's assault on our democracy on January 6th makes him unfit for public office in the highest office in the land. The American people must decide if Trump's embrace of violence to preserve his power is acceptable. Perhaps most importantly, the American people must decide if they want to entrust the president once again, the presidency, to Donald Trump, now knowing he'll be even more emboldened to do whatever he pleases whenever he wants to do it. You know, at the outset of our nation, it was the character of George Washington, our first president, that defined the presidency. He believed power was limited, not absolute. And that power always resides with the people, always. Now, over 200 years later, today's Supreme Court decision, once again, it'll depend on the character of the men and women who hold that presidency that are going to define the limits of the power of the presidency, because the law will no longer do it. I know I will respect the limits of the presidential powers I have for 3.5 years, but any president, including Donald Trump, will now be free to ignore the law. I concur with Justice Sotomayor's dissent today. Here's what she said. She said, in every use of official power, the president is now a king above the law. With fear for our democracy, I dissent. End of quote. So should the American people dissent. I dissent. May God bless you all. May God help preserve our democracy. Thank you. May God protect our citizens.
Let's now bring in CBS News senior White House correspondent Weijia Jiang as we watch the president after his remarks. Weijia, the first public remarks.
Do you think it's a valid concern to say that this decision can end democracy? I think that democracy in the United States is robust enough that no single act can end it. But it seems to be going in a direction of giving an undue amount of power to the executive that I don't think there's good justification for.